Dear audience, my name is Tetiana Antsupova, and I am a senior fellow at the British Institute of International and Comparative Law and the leading researcher of the project The Dynamics of Judiciary in Ukraine in the context of the rule of law and the European Union Accession Aspirations. The project is consulted pro bono by the advisory board, comprising prominent current and former national and international judges. And today, 15th of November 2024, I am delighted to continue the series of interviews with the members of the advisory board and to introduce my guests, my former colleagues, judges of the Supreme Court of Ukraine, Olena Kibenko, Kostiantyn Pilkov, and Ivan Mishchenko. Let me focus on your background and introduce you to our audience. Judge Olena Kibenko spent over 25 years in academia and 15 years in private practice, specializing in commercial and comparative law before joining the judiciary. She has authored over 160 articles on corporate and commercial law, contracts, and legal standards in Ukraine, along with several books, including Corporate Governance and Company Law, Comparative Study of European Union Acquis and Ukrainian Legislation. In 2005, she received the President of Ukraine Award for Young Scholars for her contribution to corporate law. Judge Kibenko led the Supreme Court's Management and Communication Working Group 2017-2021 and coordinated its Strategic Development Group 2021-2022. She is also a member of the European Bank of Reconstruction and Development's Online Courts Project Working Group. My next guest, Judge Kostiantyn Pilkov, is a judge of the Grand Chamber, which he joined in 2020 and was re-elected in 2023. Just for notice, the Grand Chamber addresses key cases to ensure consistent legal interpretation across commercial, civil, criminal, and administrative law. Before joining the Supreme Court, Judge Pilkov worked as an attorney and arbitrator at national and international arbitration institutions. He has written books and research papers on evidence and proof on international commercial arbitration and court proceedings, and lectured at Kyiv National University of Trade and Economics from 2016 to 2022. And my another colleague, Judge Ivan Mishchenko, has been practicing law since 2006, serving as managing partner at Trusted Advisors from 2014 to 2017. He is specializing in contract and property disputes. He co-authored and trained on the Structure of Judgments course for Supreme Court judges. Since 2021, he has chaired the Selection Commission for the High Qualification Commission of Judges, which began operational in June 2023. Following the full-scale invasion in February 2022, Judge Mishchenko joined the Ukrainian Armed Forces for more than 1 year, and currently he continues his role as a Supreme Court judge. Thank you so much for accepting my invitation, and I feel very privileged to have you all for today's discussion, considering you play a special and active role in capacity building of the Ukrainian judiciary, because all of you joined the Supreme Court in 2017 as a new generation of judges after the comprehensive judicial reform. All of you are judges, speakers of the Supreme Court, and adepts of European integration, judicial diplomacy, active role of judges, and etc. It unites you as representatives of the group of judges who are drivers for the positive changes, as we all hope. So I'm very much looking forward for inspiring conversation today. And let me start with the question that I decided to put as a first one, after my previous video interview with Judge Paul Lemons, he mentioned that something he has observed with the people who have been under Soviet rule, a fundamental distrust of the authorities. And in his opinion, to restore that trust will take many years and also generations of officers who see their office as a service to the country and not as a means for personal enrichment, etc. So it's a question on mentality, and it will take time, he said. I suggest let's start from this multi-leveled issue, which with trust and confidence in the judiciary and state authorities such, from different perspectives. And my first question will be, considering Ukraine is going through all sorts of reforms and experiments for the judiciary, do you think that such compensation for lack of trust through more complex and transparent selection procedures, including the participation of international experts, can bring any positive changes? Ivan, I will probably ask you first because you are directly involved into selection process. So what is your opinion?
Thank you, Tatiana. Hello. Thank you for having us today. Well, this question alone can be discussed for hours and hours. So I'll try to summarize what my experience is. It is true that I'm still a chair of the selection commission that selects, that actually offers the possible members of the High Qualification Commission of Judges to the High Council of Judges that finally appoints them. So to put it simply, we, with our colleagues, we select the selectors. And our commission consists of 3 Ukrainian judges and 3 international experts, one from the Netherlands, one from Canada, and one from USA. What is interesting about this commission is that, as envisaged by the law, by the special law that established this commission, to take any decision or to block any decision, you need to have at least two international votes. So internationals have decisive vote on my commission, and this is not a complaint. It is just the rule, right? But it reflects how Ukrainian society tries to rebuild its judiciary by giving the international experts the decisive vote. And when we had some criticism on this model, we often heard that as if Ukraine is not independent, as if Ukraine as a state needs somebody from outside to govern its purely internal issues. Show us any other country in the world where internationals decide such crucial issues in the judiciary, they said. I don't think, in my experience, this is not relevant. We have a very good connection, and we can take best practices from our colleagues from all around the world. And these mutual projects can be quite successful. However, again, it reflects the problem of trust, of lack of trust. Ukrainian society is quite young. Our country has got its independence only in 1991, after 70 years of Soviet dominance, of totally different culture. And the Soviet state was a perfect example of absolute absence of trust to the state, because it was like a schizophrenia. all the official, well, every Soviet citizen had two lives, like official life where there was Lenin, there was party, Communist Party, and we competed with America, and the real life where official propaganda was mere a joke, nothing real. So in this particular circumstances, this feeling that the government doesn't care about reality, he cares about this fake picture that he tries to recreate all the time. I think we have a part of it in our mentality, and I agree that it will take us a long way to go. However, I believe that all the efforts we do already have some serious results, just because if we compare our judiciary to what was 20 years ago, 10 years ago, and what we have now, it's three absolutely different pictures, absolutely different situations and contexts. Tatiana, if I might ask you, please stop me if I will speak for too long, because I don't know when to stop. So please do.
Okay, thank you so much for your kind response. And I do agree with you totally. And it's interesting that we are talking about Soviet heritage actually after 33 years after Soviet Union collapsed, and it's just incredible. I think Kostiantyn wanted
if I
to add something.
if
Yes.
I might
Yeah.
weigh in with some comments reflecting on what Ivan just said, without any undermining of what he's doing. I might just add that obviously the selection procedure shall not cast any doubt on the result, but in Ukrainian realities, I believe that we put too much pressure, too much importance, and on the procedure, and sometimes even the participants of those procedures are trying to picture the whole procedure and the result as something magical, as something that is guaranteed, that guarantees the results. And after something happens with the judge that was selected through a complex and elaborate procedure, then they start pointing fingers, pointing at each other, like saying that, for example, it's not us, it's you who didn't reveal something in the biography of such and such candidates, as if the selection procedure guarantees for the future years the performance, the integrity, and the highest moral qualities, that they will remain the same. It's absolutely not only impractical, but even theoretically impossible to guarantee that on the stage of the selection. So certainly the details of the selection procedure, the tendency of making it difficult to pass, certainly it's a Ukrainian reality. But what really adds to the trust and confidence in the Ukrainian justice, and I believe all over the world, it's not the selection procedure. It's, according to my personal belief, it's the competition. First of all, I believe that the Ukrainian state has to embrace with open arms the alternative dispute resolution techniques, so that Ukrainian courts compete in quality of their work with arbitration, with other means of dispute resolution. And then when the citizens, when companies choose state courts, that's where the trust, which is above just the legitimization, where we reach that level of real trust. Certainly, the issue of understandable language of the judgments, the reasoning of judgments is another element of trust. It's not that the judiciary is not the holder of the secret knowledge anymore. The knowledge in today's societies, in today's world, is fused, is shared with everyone. Any any lawyer with high competence has almost the same knowledge, or the same knowledge as the most qualified judge in Ukraine. So it's not that judges possess some secret knowledge for which they have to be revered, trusted, and respected. It's the way they explain their decisions. So I hope that we will have the opportunity to talk about that in more details, but the well-grounded and well-reasoned judgment has more importance and more weight in the trust and confidence in judiciary than the procedure by which the judges are selected, in my opinion. Thank you for letting
thank you
me
so much, Kostiantyn, and thank you for
reference.
Thank you for turning the discussion to this direction, because it was actually the question I was going to ask you about the motivation of judgment and about the civil society expectations, and the huge discussion in academic world, and practitioners are also involved into this discussion, which is about if court should respond to any argument in its judgment, any argument of the parties, or if they are obviously irrelevant, then the court judge, reporting judge, could ignore them. And let's then finish. If Ivan, you would like to add something about the selection procedure, and then we will continue with the motivation of judgments.
So thank you. So a couple of thoughts. Thank you, Kostiantyn. You raised a very important issue. So what I think about all these competitions, we have a lot of different commissions now in Ukrainian judiciary. Almost every position in judiciary, in every court, you can get only by way of competition. And this is the idea, this is the real idea behind all this process. When you can be, as my friend Stephen from the commission says, when you can be elevated from any position that you have through the fair and honest competition to any position that you are eligible to take. So this is the social lifts, in fact. So the commission, the commissions in their essence are not the scrutinized and complex procedure who must guarantee for 100% for the rest of their lives the integrity and professional competence of the candidates. No, that's impossible. We live in the real world. Instead, they create the possibility, they show the society, look, anyone can take this job, anyone, and you can see that. And the international experts in these commissions are, they are the guarantee that it is for real. It is not because it was in Soviet Union and many years of Ukrainian independence. So one could take especially some important position just because somebody helped him, just because of some shadow connections, just because some negotiations that nobody saw. And now you can do it by way of honest competition. So I think this is the essence of all this commission, and this is the way that they can bring back the trust. Thank you.
Yeah, thank you, Ivan. It is a great change, definitely, in procedures of occupying the position in judiciary. A great change. and all of us, we've gone through the open procedure of and selection process, so we know what we're talking about. And moving on, and to another question, as we pointed out, about how motivation of judgments can contribute into building of trust and confidence in judiciary. In your opinion, how far we should go in motivation of judgments, and not to make it, ridiculous. And in my point of view, sometimes some arguments of the parties are totally irrelevant to the case the court considering, which is under consideration of the panel. So should we be responsive to any single argument, or should we use a special methodology? And being a part of the working group as Ivan on structure of judgments, we suggested different approaches, like chronological approach, issue approach, to structure the judgment, to make it clear to the public. Do you think in a long or short-term perspective, it may contribute to the confidence in the judiciary?
Well, I might start as always, just a bit. So first of all, Olena is also in that movement for new kind of
Yes.
new kind of way of writing and doing judgment, as well as Kostiantyn. Well, how can we go without Kostiantyn, right? So just very shortly, I think first of all, it's a global tendency. It's a global feature. What I've learned in different international conferences and meeting with my colleagues all over the world, that almost every country works on the so-called plain language for the judgments to be more understandable, more open to the public, and it serves for a variety of reasons. It is a trust. It is the way to clearly understand for a clever person what were the motives and arguments for a judge. I think that this is a step, a very important step of the judiciary towards the society. It is the openness, because it is very easy to hide yourself in that castle made of all these legalese and all these complex words and all these long sentences, so nobody could understand what actually is written in the judgment. But we need, it's not the society who has to approach us and try to understand what we meant by saying this or saying that. It is we who should do that and who should open ourselves. And of course, it's another step on the way to rebuilding trust. Thank you.
Thank you, Ivan. I would like probably to pass the floor to Olena, because she is very much involved and an expert in electronic courts, and I would like to just touch a very technical issue and another aspect of building the trust and confidence in judiciary, which is allocation of cases to judges. And at present, it is based on a randomized system and objective criteria. But in opinion of the European Commission, it should be further improved as part of the renewal of the Unified Judicial Information and Telecommunication System. So in your opinion, Olena, is our system is not transparent enough, not improved enough? Is there still any room for abuse, this system? Should we improve it? Just a short comparative analysis, considering you are very actively involved into discussion with the foreign colleagues and traveling a lot and communicating a lot with our colleagues from abroad.
Thank you, Tatiana. It's very interesting questions. And going back to the question of trust, I would like to tell you that people of lack of trust makes our job very difficult because many rules in Ukraine EP that doesn't exist in any other countries. And for example, we have a very, very complicated system of auto allocation, auto assignment of the cases. And I think our system is very complicated and the most complicated in comparison with other European countries, for example, or with the United States system. And we have a huge manual instruction, special computer system to do such assignment of the cases. Protocol drawn and made publicly available, and everyone can see this protocol of assignment or allocation of the cases. But I know that in other countries, just chairman of the court can assign cases. Or, for example, one of the United States courts, I know that judges just draw cards from a small box to assign the cases, or use some other very easy practice, and no one doubts it. No one can tell that this is corruption practice or something wrong with these procedures. So I think our system is good enough, and just a matter of trust, not a matter of quality of such computer system, of such programs, and so on. For example, I recently was in the United States, and I met with one of the judge. It was a district judge, and he told that he often is only a judge on this district. And I asked, what about assignment of the cases? What about the system of allocation? And he didn't understand my questions. He told me, I'm judge of the district, and people know that I'm the only one, the judge who had all these cases, and he doesn't understand what's the matter, what's the problem. And concerning motivation of our decision, of our judgments, also we need to motivate our judgments in more detailed way than our colleague abroad. I know that many judges abroad doesn't need to motivate orders or not important judgments. We do that because we need people to trust us, and we need to explain our decisions. So the lack of trust in judiciary in Ukraine according to the lack of this trust, we have to motivate our decision more carefully, in more detailed way than our colleagues abroad. But this is our way, and this is our choice.
Yes, thank you, Olena. It seems like it's our evolving way, and no revolution can change it. It just takes time. That's it. And Judge, Judge Pilkov, I wanted to say Judge Pilkov formally.
Yeah,
Kostiantyn wanted to add something. Yeah.
Add to that. Yeah, it's also a unique case of Ukraine, when a complex and elaborate system of this allocation of cases that works who knows how on a computer that is who knows where. It's not in a particular court. It's located somewhere under the auspices of the state judicial administration. The interference in that system is punishable by according to the criminal code. So this system works so complex, but again, by the Ukrainian society and by legal professionals, that is considered like, meh, okay, it works, but it doesn't add significantly to the public trust and confidence in the judiciary. It's just accepted as it is, without any significant impact. Again, I recently read the result of a study on how people trust governmental institutions, and the general takeaway is that when there is a tendency of decline in trust, the amount of regulation increases. Again, this is what we have. This particular system of allocation of cases doesn't that much. And Ukrainian courts are overloaded with technicalities, with some issues that are burden on the judge, and the judge has to deal with them instead of thinking about complex legal issues. Again, needless to say that the final decision of the court needs to be well-grounded and well-reasoned. But that said, it doesn't mean that the judge needs to explain every step, every procedural decision that they take. As Olena just referred to the experience of our colleagues from the United States, who do not explain in documents in 4, 10, or 20 pages every procedural step they take, as Ukrainian judges need to do. For example, only recently we managed to get the legislature to make it easier for Ukrainian courts to appoint video conferences. Up until now, for 6 years, the whole composition of the court. For example, I'm currently serving in the Grand Chamber of the Supreme Court, and Tatiana, who was my colleague there for several years, knows
And
that
Olena.
perfectly. And yes, but yeah, that in order to appoint the video conference, the resolution need to be signed by the whole composition of the Grand Chamber. It's 21 judges in its full composition. First in paper, then in the digital system. For one technical issue that is worth switching off the light switch. That's how it should be done, not by way of drafting and then uploading to the state court register a ruling signed by 21 judges to decide. Moreover, it has to contain at least some explanation. What's there to explain? So I believe that our work, the work of judges who are the proponents of this evolution, of this simplification of the procedure, of taking away from the judge every technical issue that doesn't need to involve intellectual input. It's a continuing process. That's where we need to apply our time and resources, and that's where the trust is built in well-reasoned final decision. Especially, that's where we have to understand the difference between courts, especially since we are all judges of the Supreme Court, whose opinions have this quasi-presidential value. That's where we need to apply our time and efforts to provide clear explanation of our legal opinions, not to spend valuable time and taxpayers' money for reasoning whether to grant or not the video conference for a party. Thank you. Thank you.
Yeah. Thank you for such a bright example, Kostiantyn, because I think it will link our discussion to the other part, which will be about the communication with society. So how should we prove the society if there any problem? Don't you trust us, in arranging this video conference? Why should we sign this decision by 21 judges? And thank you so much. The last question in this big discussion of trust I would like to ask is about style of life and financial declarations on family relations and integrity, which every judge in Ukraine is obliged to submit on an annual basis. So can it restore somehow the reputation of the judiciary, or does it just put additional pressure on judges and nothing else? Just shortly about this question, maybe Ivan can start.
If I'm not mistaken, the declarations exists for more than 10 years, something like 12 or 14 years. And the declarations itself, different kind of declarations, financial one, declaration of integrity or family ties. The declarations itself, well, I believe that they are the part of judge's career. So on the other hand, have they restored actually the trust in the judiciary? Well, I don't think that they succeeded in that direction. Some of them are a major formality, and instead of fixing these declarations, that some of them might not work anymore, or they have lost its initial goal and essence, instead of fixing it or getting rid of it, Ukraine has a style of thinking and bringing out something new. The only example that I have, I think that it illustrates the situation. Every judge in Ukraine has to file a declaration called a family ties declaration or something. So he or she should indicate who else in his family works for the government in general. I don't have any relatives working in the government, for better or for worse. So each and every year, I have to fill in that. I have to file the blank declaration, and if I don't, then there is some kind of a responsibility for not doing that. But what if to change a little sentence in the law saying that if something changes, then you should file this declaration? For what reason do I have to file the blank declaration every year? And of course, nobody reads it, never. Thank you.
And of course, you know, to put it even easier, the law can stipulate that only those who have relatives
Right.
can declare or should declare. Yes, there are many nonsenses in and which, as I said, which puts so much pressure on judge, because there is a deadline till when you should submit all kinds of documents, saying nothing actually sometimes.
Well, it's the same. I think that this idea is one of the core ideas of the whole our discussion. So we lack common sense quite often. We need that common sense. Not the ritual itself, not the procedure itself, but does it work? Does it help? Or it's just a waste of time and resources for no reason at all.
Thank you.
Can I jump in discussion? I have another very good example that we have to file each month declaration with our salary. It's so funny because everyone knows that we got this salary. No, it's a public law. It's everyone knows about this. But each month we have to file this special declaration and to declare that we got this salary.
Income.
Absolutely absurd. And declaration is a very important step for Ukraine is to fight with corruption and so on. But we have so many these boring rules that it's not necessary now. So we have to improve the situation with that.
Thank you, Olena, for this remark, and thank you for mentioning a corruption issue, because I would like to move our discussion to this question, which we probably can't avoid and which contributes to the huge discussion on trust to the judiciary. So at the beginning of our meeting, of our conversation, we mentioned this Soviet heritage and its influence on minds, and what it's actually to be Soviet-minded. What does it mean? how does it affect the system of values at present days in Ukraine in the context of corruption? What would you say? What is your point of view on this issue? Kostiantyn, maybe you can start.
If I might show you, I have this sketch by a sketch artist, and it was presented to me by my friend and colleague, fellow attorney in 2017, as a reminder, so that I do not end up like this guy here. This sketch represents the so-called phone law, an expression that is probably unique for the post-Soviet countries, understood there and understood in Ukraine. It's a special type of corruption that is not even was not even considered as a form of corruption until recent years. It was sometimes considered as a way, as a special skill of dealing within the state apparatus, a special skill of statecraft, the ability to know how to solve things within the state apparatus. And actually, that system involved the complete silence and the promise of protection of those who participate in that system. It was not considered as a classical corruption case, as a form of corruption, because it did not involve the direct financial or some other material gain. But yeah, kind of from our perspective, it's definitely a form of corruption. Moreover, in today's Ukraine, probably it's one of the most toxic, most important to understand and to fight. Actually, now only the remnants of this system is working, and only by inertia, because those who enjoyed that system in Soviet era and some years that followed that era, they still believe that since that system envisaged complete silence and protection in return, if they remain silent and abstain from any public activity, self-isolate, they receive that protection in return. There is the logical fallacy, there is the logical mistake. That system works only in their mind. I believe so, and I hope so, that we will never return to that. But now, in these times of war, in these times when the state is like monolith, when the checks and balances sometimes do not work properly, there is a significant risk that, again, this telephone law, this ability to hear important people from above, might return in the practice. And that's where we need to be to get involved and understand that only the transparency, the openness, the communication of judges, which is quite opposite from the complete silence and self-isolation, needed to be promoted. I mean, this involvement in communication, this openness and transparency. So that's why we, my colleagues, and other members of the judiciary who are socially active within the judicial, within the lawyer societies, need to stay involved, because that's the matter that protects our integrity, our independence. Actually, this communication, this constant involvement in open communication with the society and legal communities, with our colleagues. If we go otherwise, if we self-isolate, we have probably, we can face this risk of getting back to that phone law, to that awful form of corruption that for many years was not even recognized as a corrupt practice. Thank you. Thank you, Tatiana.
Thank you, Kostiantyn. So you think that such a background like war may have a negative influence, and it's not just an individual psychological deviation when every individual has a choice to be a part of corruption scheme or not to be a part of corruption scheme. It is also the influence of such a, I don't know, objective environment or just system around background of war, as I said. It may affect hugely and make a regress in.
Oh, definitely. We have such a risk. Certainly, the war being in itself an extraordinary phenomenon brings extraordinary in people, reveals their qualities in extremes. And certainly the war requires to put individual values below the common common benefits, and sometimes under the pretense of dealing of protecting the common values, common benefits, some fishy business might be like communicated, which had some like private interest in it. So especially in times of war, it is possible that under the placard of protecting important common values, some very important private values might be protected, even without involvement of classical cases of corruption. I mean, those that involved direct quid pro quo with those who decide, with those who make the decision. So I mean, certainly the war, although in view of many Ukrainians, and I believe I'm one of them, in times of war, any case of corruption, any corrupt act shall be deemed with doubled severity. For probably for someone, the expression that the war is the time of opportunity might mean something not very good, certainly. But again,
Yeah, you're right. Absolutely, I agree with you that challenging time of war is a challenge as well to democracy, human rights, and rule of law, in generally speaking. So it's very difficult to uphold justice, rule of law, democracy in times of emergencies and times of law, and to ensure it for this society. Thank you. If Ivan and Olena have nothing to contribute into this question, we can move then to
how you can contribute after Kostiantyn. Well, it seems quite challenging.
Especially on the hot topic of corruption.
I have an idea how to do it.
But please, colleagues, do not remain silent. Talk about that.
Okay.
Yes, Olena. Yes.
I think that Ivan should say that I think it's very important to how to deal with corruption, with this old Soviet style of thinking and so on. It's very important now to renew our judicial system and to get new judges from another profession, from academia, from law business, from legal profession, and now we try to do that. And Ukraine has, if I'm not mistaken, about 2,000 of new judges, and I think these new judges can us fight with corruption and can change everything in judicial system. And it's very important to educate them properly, to communicate with them properly, so this new blood can change everything in judiciary and can fight with this corruption, with this old practice, with this phone law and so on. I'm optimistic, and I hope that these new judges can change everything.
Well,
Thanks.
just one remark. We don't have them in the system. They should come in the system, and we hope it will happen soon. So now I believe that there's a competition for something like 500 new judges.
To the courts of appeal, right?
Yeah, to the courts of appeal. So we still need to find somewhere 1,500, and I believe that's quite a task for the new HQCJ for the next year, and possibly for the 2026.
Yes, thank you. Thank you for this very valuable addition. And I do believe in new generation of judges as well. And I think with them, we should talk more about the preventing corruption, because fighting the corruption is the matter of another other institutions. So hopefully they could prevent corruption in judiciary. And thank you for your answers. So the last cluster of our discussion, I would say, would be dedicated to communications in judiciary, communication policy, communication strategy. And the general question is, does the judiciary has an independent voice, or it is still dependent on the political will of the ruling party? So this out of the courtroom activity, judicial diplomacy, as we call it, and which ensure the independence, in my point of view, ensure the independence, the independent voice of the judiciary. Does it contribute in build of trust? And as well, in my point of view, it connected very much to the issue of independence of the judiciary. And I can cite just one sentence from the Ukraine report 2024 of the European Commission on the enlargement policy. So the European Commission says, overall, the constitution and legislation guarantee the independence of the judiciary, but certain shortcomings persist in law and in practice. I think it is very important part of work, as I said, out of the courtroom activity and communication, internal, external communication, communication with society, communication with colleagues, foreign colleagues, different societies and different associations of judges, how it works at present. And I know that you are contributing a lot into this out of the courtroom activities. So just a few words about your experience.
We live in the world where communication is everything. So if something happens and it's not on Facebook, then it never happened. It's so simple. But if to take it more seriously, of course, the judiciary has to have its own voice. I have a feeling that for a number of years, the judiciary had this instinct to hide somewhere, and especially to hide from reforms, not to express any direct thoughts, not to express any direct positions, just to adapt to what is happening. And hopefully this time, these changes will not dramatically touch upon the things that are normal things that are going on. But I have a feeling that the judiciary has to have its own position, because if you are independent, then it is a must to express your direct views, and without that, if you are silent, then how this independence can be particularly expressed? How can it be seen from outside? So in that regard, of course, I believe that we have to, and what Olena was saying about these new generation of judges or new judges coming into the system, I hope they have this mentality of perception that everything is communication. And of course, communication is the vehicle for the trust. Without adequate communication with the society, I don't believe that we can regain trust or to build adequate trust level in Ukrainian society. Thank you.
Thank you, Ivan. So, what is the best way to organize this communication with society? You mentioned social media is one of the tools. Considering all of you are judges, speakers, do you believe in this institute of judges, speakers? Should judges, speakers comment, for example, in case of and provide prompt reaction in case of fakes and disinformation about the judiciary or particular judges? How should this work? And does it work at present?
Colleagues, does it work at present?
Kostiantyn, maybe you can
I
share
believe,
your experience.
Yeah, I heard what Ivan said about and what Tatiana asked about the voice of judiciary, and I have this thought, but whose voice is the voice of the judiciary? Is it the voice of the whole system? Who represents it? Is it the voice of a particular institution? Then who represents it? Is it the head of this institution, or judges, speakers, or the spokespersons of that institution? And again, I remind this thesis that the communication nowadays is a matter of not just being visible, it's the matter of the preservation of the independence of the whole judiciary, of a particular judge, and for the whole judiciary. And I might become a little bit boring, but still, I'm a judge, I'm a lawyer, by referring to the European Court of Human Rights case law, recent case law related to Poland, the so-called case Żurek against Poland, and there are similar cases on the European continent. And
do you remember the number of these cases? Can you provide us? No. Okay.
I
sorry.
will send the links to that judgment,
great.
where the European Court of Human Rights and then the European institution promoting the judicial independence and the principles in the judiciary, they said that the right of the judge to speak, the right of the freedom of expression of opinions now transforms into the moral and even legal duty to speak out if we are talking about the necessity to defend the fundamental values such as the rule of law, the basic principles of the democratic society. So actually, we are in the situation, especially in Ukraine, especially in times of war, when the role of a single judge might change. It's no longer just the work on the particular case. It's definitely not the role of a silent executor of a higher will. It's the role of a fighter, of a protector of the rule of law within a particular country. And for that reason, the judge might be in a situation which is unfamiliar for him or her as a communicator, as a speaker. So not only judges who are speakers of their courts, but every single judge, especially in new democracies or in countries where the democracy is on the brink of collapse or where there is a risks for democracy, the judges might reveal themselves in the position of defender of those those values, and especially in public, in open, in communication aspect as well. So we need to be ready to perform that not only as our inclination to be public, but as our moral and even legal duty to speak out in defense of the rule of law.
Thank you.
That's why, yeah, again, that's why the communication of every single judge is so important, but because it has no justification for being silent anymore, especially in Ukraine.
Thank you. And I would like to emphasize that our today's conversation is also contribute to communication to society and colleagues, especially English-speaking audience. So it is a part of work as well. And the last question I would like to ask you, turning from the communications with society and external communications to internal communication, how much it is important to uphold institutional culture and institutional corporate climate in the court, how much it is influencing on efficiency of justice, on effectiveness of every particular judge. Maybe, Kostiantyn, you can continue on this matter as well.
Again, yeah, we need to transform this widely accepted corporate culture of being silent, remaining silent, holding this veil of secrecy under which might be a wisdom. We have to transform that, since in today's society, in today's world, it's no longer the case. The silent does not appear as wise just by presumption.
Yes, and we are talking about this silent approach as an approach of old school judges, as far as I understand.
Exactly.
That's why I asked about this institutional climate, how hard it may be sometimes to find a way of expression, the opinion, considering that probably the vast majority of the judges of the Supreme Court as well, they are.
Well, if I may,
Please.
The issue with Ukrainian courts sometimes is, I believe, the direct legacy of Soviet system, where we have a president of the court, when he or she does everything and holds the complete responsibility for everything that goes inside the court and outside the court. And I believe that this system is so outdated, so ineffective for a number of reasons. Because one person, even an amazing one, a particular one with some amazing qualities and everything, it just cannot handle all these difficult processes that going on every day. So what I would think that is, we need to introduce somehow a new culture of team leadership. So this pyramid structure should slowly go away, just because, well, everyone has its own unique expertise, and everyone can use this unique expertise to make the court better, to make the judiciary better. And oftenly, you don't need some special administrative position. However, in Ukraine, sometimes it's easier to get things done. But Olena here is an example of the person who did so many successful projects in the Supreme Court without any administrative position. And it didn't prevent her from gathering like more than 50 judges in a strategic group that have made a lot of reforms. And it happened without, well, there was a participation of the heads of the court or presidents of the court, but still, it was Olena who made it real, and not the officially elected officials, I might say.
Yes,
okay.
it is a hard. Yes, thank you, Ivan, for your remark, because it is important to emphasize that it's a hard work, this out courtroom work. It is a hard work, and it is an easiest way just to stay in your office and look through the papers and not thinking strategically, so to speak, or institutionally. So it is a hard work, and thank you so much for, let me conclude. Thank you for your incredible contribution into our project, and which includes not only today's conversation, but also publication of the concept paper for the Ukrainian judiciary on the project webpage. And thanks all of you, and especially Olena today, for finding time in between your court hearing. I know how difficult it is. And I would like to thank the Beagle event team for the technical support of this interview. Thanks everyone for the attention. And in case you would like to add anything, the floor is yours, dear colleagues.
Thank you for inviting us. It was a very good experience for us to participate and to be open and to show everyone our thoughts.
Well, 4 lawyers had a conversation just a little bit more than an hour. I think that's amazing.
We did really well.
Yeah. Thank you. Thank you.
I hope that it's not a goodbye, but that we continue. That's not all that we can do, and I hope that in the future we add to the transparency, to the openness, to the better judiciary in Ukraine. Thank you, Tatiana. Thank you.
Thank you, dear colleagues. Thank you.